be talking about the overview of Nextera's tax abatements
Yes.
for power plants.
Part of our overall 2011 abatement request this year, we received one from Nextera Energy, the majority owner of the Seabrook Nuclear Power Plant. And along with its partners, they filed, this year, they filed an abatement request. So I wanted to update the board and the residents of Hampton on the progress of that. This abatement request isn't a typical request where there's a value opinion, you know, that most abatements are filed on. The basis of this filing has to do with an approval in 2011 granted by the New Hampshire Department of Environmental Services. What they did was grant the plant's request to increase the percentage of value attributed to their pollution control exemption. The percentage in place prior to this ruling was approximately 14% and had been in place since the Supreme Court ruling back in 1992. The percentage approved by DES in 2011 has increased the allowable amount of that pollution control exemption up to 26% of the plant's fair market value. Based on this current decision, the tax impact to Hampton is still unknown because of two reasons. Within the DES decision on page 3 under section 2, applicable law, paragraph 5, it states that the taxing authority, not the property owners, must determine the appraised value or fair market value of the facility and exempt that percentage of value and associated real estate that is attributed to the pollution control exemptions under RSA 7212A, section 5. At this point in the abatement process, Hampton has not completed the valuation process associated with those components located within the town, and we still need to. Therefore, assuming a worst-case scenario at this point is a bit premature. But it should also be mentioned that there was an appeal of this decision filed with the New Hampshire Supreme Court, and it was filed by the town of Seabrook. They are requesting a reversal or remand of the decision, and this appeal has not yet been decided. An oral argument on this appeal was held in February of 2012, and it may be some more months before a decision is handed down. Among other things, the appeal is based upon the fact that DES allowed only a limited time for comment on the Nextera application for pollution control exemption and refused to conduct a hearing as requested. So just to sum things up, if we were to estimate the impact as it currently stands using only the owner's opinion of value as set forth in the owner's abatement application, and again I want to stress that these figures are only the opinion of the property owner and not the town of Hampton, which is the responsible party for determining fair market value, not the property owner. The estimated impact using the owner's opinion of value, which is approximately $7 million, compared to our 2011 assessment of approximately $39 million, would result in a difference of approximately $32 million in assessed valuation. This estimated impact would then equate to an abatement refund of approximately $500,000, again based on the owner's opinion of value. Finally, if the owner's figures are used, this could result in an increased tax bill of approximately $66 on an average single-family home and an estimated increase of 17 cents on the tax rate. However, again, I want to reiterate that these figures are based on the owner's opinion of value and not the town of Hampton's. I don't know if you have any questions, but...
Questions for Mr. Tinker? Mr. Pierce?
I don't have any.
Mr. Moore?
Thanks for the updated.
Yep.
Thank you for a wonderful brief and the transparency. And I would say that in observing, in listening to you, and attending meetings, and reading the state documents, that a tremendous amount of confidence is placed in you and Attorney Gerald, and I think it's well deserved. Thank you.
I appreciate it. Thank you.
Mr. Nichols?
No comments. I think Ed said it all.
Thank you very much. Thanks for joining us this evening.
Good night. Thank you.